Finally tonight, as promised, a special comment on the Supreme Court's ruling today in the case Citizens United v. Federal Election Commission. But good news tonight, Roger B. Taney is off the hook. Today, the Supreme Court of Chief Justice John Roberts, in a decision that might actually have more dire implications than Dred Scott v. Sanford, declared that because of the alchemy of its 19th century predecessors in deciding that corporations had all the rights of people, any restrictions on how these corporate beings spend their money on political advertising are unconstitutional. In short, the First Amendment, free speech for persons, which went into effect in 1791, applies to corporations, which were not recognized as the equivalents of persons until 1886. They can spend all the money they want, and if they can spend all the money they want, sooner rather than later, they will implant the legislators of their choice in every office, from president to head of the visiting nurse service. It is almost literally true that any political science fiction nightmare you can now dream up, no matter whether you are conservative or liberal, it is now legal. Because the people who can make it legal can now be entirely bought and sold. No actual citizens required in the campaign fundraising process. And the entirely bought and sold politicians can change any laws. And any legal defense you can structure now can be undone by the politicians who will be bought and sold into office this November or 2 years from now. And any legal defense which honest politicians can somehow wedge up against them this November or 2 years from now, that can be undone by the next even larger set of politicians who will be bought and sold into office in 2014 or 2016 or 2018. Mentioning Lincoln's supposed ruminations about arresting Roger B. Taney, he didn't say the original of this, but what the hell? Right now you can prostitute all of the politicians some of the time and prostitute some of the politicians all the time, but you cannot prostitute all the politicians all the time. Thanks to Chief Justice Roberts, this will now change. Be prepared first for laws criminalizing or at least neutering unions. Be prepared then for wars sold as the new products, which Andy Card once described them as, year after year, as if they were new Fox reality shows, because military-industrial complex corporations are still corporations.
And now, as promised, a special comment on the hysterical left-wing reaction to the Supreme Court's decision in the case Citizens United v. Federal Election Commission. The irrationality and partisan paranoia which permeates this reaction were perhaps the most epitomized in the comments of Keith Olbermann on this subject. The flaws in his reaction were many, and by the end of my argument, I hope you will understand that he has debased himself to the demagoguery that was once solely the domain of the likes of Bill O'Reilly and Glenn Beck. Mr. Olbermann opened his comment with a comparison so hysterically hyperbolic as to be intellectually obscene. Not only did he form a tenuous connection between Dred Scott v. Sanford and the Citizens United case, he referred to Citizens United v. Federal Election Commission as a decision that might actually have more dire implications than Dred Scott v. Sanford. With this comparison, Mr. Olbermann reveals a fundamental ignorance about the law at hand in this case. To discern the absurdity of conflating the cases, one only need examine the language used to summarize each legal decision. In the Dred Scott case, the defining statement was that African Americans possess no rights which the white man was bound to respect. This statement, a bastion of bigotry and an insult to every concept of individual liberty, stands in stark contrast to the defining statement of the majority opinion in Citizens United. When government seeks to use its full power, including the criminal law, to command where a person may get his or her information or what distrusted source he or she may not hear, it uses censorship to control thought. That is unlawful. The First Amendment confirms the freedom to think for ourselves. That was the defining statement of the majority opinion. Mr. Olbermann, how dare you compare one of the most vile denigrations of human liberty to a recent decision which affirms this nation's commitment to freedom of speech? Mr. Olbermann, sir, have you truly let emotion, a visceral hatred of corporations, lead you to become all you have righteously and rationally reviled and refuted? Sir, rather than rationally and empirically examining the truly deleterious impact of corporations upon this nation, in a political discourse, you launch on a rant so disconnected to reality that I found myself thinking, am I watching the Glenn Beck show? Why, sir, are you willing to undermine your credibility by indulging in paranoid dystopian fantasy when there exist a litany of examples of the evils of corporate power grounded in fact, ranging from defense contractors and the Iraq War to insurance companies and the perverse chimera that is the Senate healthcare bill? Why, sir, are you willing to ignore the very real free speech questions at the heart of this case, resorting instead to fear-mongering about the potential destruction of America? How can you let your fear of corporations override your commitment to the Constitution and remain any better than the neoconservatives whose fears of terrorism allow them to ignore all concerns of due process and privacy rights? Is not such a move more on the level of Billow the Clown than a serious journalist or commentator? It's certainly no coincidence that some of the harshest and most principled critics of Bush and Cheney's crimes, including Glenn Greenwald, Professor Jonathan Turley, and the American Civil Liberties Union, have all defended the court's decision. Furthermore, sir, how do you not see the hypocrisy at the heart of your position? Keith, you sit upon a pulpit broadcast to the masses by MSNBC, a subsidiary of GE. Your primary ideological adversaries are brought to us by Rupert Murdoch's News Corp. Under the law, which was struck down by the Supreme Court, News Corp and GE could and did use their vast aggregations of capital to impact elections, as they happen to own media outlets. Yet unions and nonprofits ranging from the Sierra Club to the ACLU to United Auto Workers to the NRA to, of course, Citizens United were subject to criminal penalties if they engaged in illicit electioneering communications. Your unhinged analysis thus comes from a position of privilege, granted to you by nothing more than the power of one of the largest American corporations, sir. Furthermore, if you are so concerned about corporate power, why not discuss how its indubitably detrimental impact might be mitigated without violating the Bill of Rights? Discuss instant runoff voting, public financing of elections, and other potential prospects for real electoral reform. Understand, sir, that the laws struck down never really stopped the gradual corporate takeover of our government, and in fact were often used to further it. Note, sir, that while your political polemics were protected speech thanks to the power of your bosses at GE, and Bill O'Reilly's rationalizations of repression were protected by the mighty Murdoch, the ACLU couldn't put out advertisements pertaining to crucial civil liberties issues. Understand, sir, that whereas your candidate, Barack Obama, brought to you with contributions from Goldman Sachs, had every opportunity to make his case, Ralph Nader, the real anti-corporate candidate, was faced with frivolous campaign finance-related lawsuits, clearly meant to stifle his candidacy. Mr. Olbermann, I empathize entirely with your rage against the corporate machine. But rage must be tempered by intellect, analysis, and principles, and you have given those up in your partisan outrage over the Supreme Court's decision in Citizens United v. Federal Election Commission. Please, sir, come back into the fold of the rational, fact-based, civil liberties-loving left and permit us to educate you on how to see behind the hysteria and hyperbole surrounding this decision. That is, if your corporate bosses at General Electric will let you. Good night and good luck.